続きまして各国の AI、IoT 関連発明の進歩性についてと題しまして、海外の専門家の皆様よりご講演いただきます。ご講演では審判制度の概要についてもご紹介いただく予定です。それでははじめに、中国国家知識産権局専利福審無効審判部電気福審第2部門副部門長シャオホア・チェン様よりご講演いただきます。チェン様、どうぞよろしくお願いいたします。
Good afternoon. I will share. Yes, I will share. Okay. Good afternoon, ladies and gentlemen. This is Xiaohua Chen from Patent Re-examination and Invalidation Department of CNIPA. Today, I'm honored to participate in this symposium as an administrative judge and give this presentation on behalf of CNIPA. My presentation includes 3 parts. First, I will briefly introduce China's patent re-examination and invalidation system. And the second one, I will introduce examination standards for invention patent applications related to computer programs in China. And the last one, I will share some information about the latest developments in AI patent application examination standards. Let's start with the introduction of re-examination and the invalidation system. As you know, the Patent Re-examination and Invalidation Department is a branch of CNIPA, which is responsible for the patent re-examination and the patent invalidation procedure. The administrative decisions it makes are supervised by judicial procedures. In other words, if you disagree with an administrative decision, you can appeal to Beijing IP Court, and you can further appeal to IP Court of the Supreme People's Court. The judgment made by the court is final. What is re-examination procedure in China? In China, after final rejection has been received, a request for re-examination has to be filed with 3 months, regardless of whether amendments are filed or not. After a final rejection, all cases will undergo interlocutory examination. After that, there are 3 possible scenarios. First, if the examiner thinks that the defects point out in the final rejection has been overcome, the final rejection will be directly revoked, and the application will be returned to the previous examining authority to continue the examination procedure. The second one, if the examiner has negative opinions during interlocutory examination, the application will be examined by a panel of examiners. Next, a notification of re-examination will be issued. The petitioner must file a response with 1 month from the date of receipt of the notification, under the condition that the response can overcome the defects pointed out. The final rejection will be revoked. Similarly, the application will be returned to the previous examining authority to continue the examination procedure. The third one, if the panel of the examiners still think that the response cannot overcome the defects pointed out, a decision of re-examination will be issued. To sustain the final rejection, the applicant can file an appeal at the Beijing IP Court. What is the invalidation procedure? The invalidation procedure in China is substantially an inter-parties re-examination, which involves three parties: the petitioner, the patentee, and the panel. The petitioner, being either a judicial person or natural person, initiates an invalidation procedure by filing a request for invalidation towards a patent. If the patentee amends the claims, the petitioner can file further grounds with respect to the amendments within a time period designated by the panel. The panel comprises 3 examiners as panel members, sometimes 5 for important cases. It usually organizes an oral hearing after the acceptance of the request filed by the petitioner. The panel's decision will be issued after the oral hearing. If the decision is unsatisfactory, both the petitioner and patentee may file an administrative litigation with the Beijing IP Court. The second one, I will introduce the evolution of patent examination standards. AI inventions usually fall into the categories of computer-related inventions. So I will introduce the evolution of this sort of patent application examination standards in advance. In fact, China's examination standards have changed a lot. From the start, only method claims were allowed. Until 1993, apparatus claims have begun to be allowed. By 2006, apparatus claims for functional module architecture began to appear. In 2017, it's clearly allowed to draft claims involving business models, claims for computer readable medium, and claims for program module hardware plus software. In the past, claims written by software plus hardware would be regarded as unclear as to the scope of the claims. At present, the general public has accepted that the special writing method, which is clear to those in the computer field. Artificial intelligence is based on data storage and machine algorithm. It is intended to simulate human thought process and intelligent behavior through using a computer. In recent years, with the rapid development of AI technology, the number of related patent applications has also increased correspondingly. In order to address issues arising from the progress of AI technology, in Chapter 9 of Part 2, a special section is added for invention patent application involving artificial intelligence, internet plus big data, and blockchain. Now I will detail the examination standards about AI-related invention. Why added this section into the examination guideline? The aim is to provide regulations on the specificity of the examination of invention patent applications involving artificial intelligence, internet plus big data, and blockchain. In Section 6, Chapter 9, Part 2 of the latest examination guidelines, it is stated that in the examination of inventiveness of AI-related inventions, the overall consideration principle and relevance consideration principle should be followed. What does mean overall consideration principle? All the features in the claim should be considered, including technical features, as well as algorithmic features or business rule and method features. Contribution of technical features and non-technical features should both be considered. What is relevance consideration principle? Technical features as well as algorithmic features or business rules and method features supporting each other and having mutual relation should be considered as a whole. In the examination of inventiveness, the mutual support and interactions between technical features and non-technical features should also be considered. The last, I will talk about some changes in Chinese legislation recently. The revised patent law Chris, I think the revised patent law was implemented on June 1st this year. The implementation rules of the patent law are in the process of revision. Corresponding patent examination guidelines with revised draft is in the process of soliciting opinions from the public. So the main changes in the draft includes patentable subject matter such as computer program products, encourage patent protection for solutions involving artificial intelligence and big data algorithms, and make it clear how to judge the technical issues and technical effects. So that's my presentation. Thank you.
チェン様、ありがとうございました。続きまして、インドネシア法務人権省特許審判委員会委員サルオノ・スティクノ様よりご講演いただきます。スティクノ様、どうぞよろしくお願いいたします。
Thank you for the time. Wait a minute. I must look for the presentation file. Okay. Okay. Ladies and gentlemen, thank you for the invitation. I am learning a lot from the other presentation. So, may I introduce? I'm actually a lecturer and member of Board of Trustees. I just appointed member of Indonesia and Appeal Committee since March this year, but active start from the May of this year. Just 5 months learn. So I must make my
Dr.
disclaimer
Stegner,
that
excuse
this
me.
is
Excuse me, Dr. Stegner. Could you put your slide on the full screen?
And as inside as a member of Indonesian Patent Appeal Committee, any view of opinion are personal and do not necessarily represent those of Indonesian Patent Appeal Committee or Ministry of Law and Human Rights of Republic Indonesia. So I must describe that Indonesian Patent Appeal Committee is an independent body on below and relative of Ministry of Law and Human Rights of Republic Indonesia. So, according to law, the member of Indonesian Patent Appeal Committee can be consist of 30%, 15% patent examiner, and 15% the experts, technical expert. But our Patent Appeal Committee this period only consists of 20%. It consists of about 10 patent examiner expert, and 10 technical expert. That the technical expert inside the 10 technical experts, 3% is law expert. So on the substantive examination, the team could be 3 or 5%, and the team must consist one law expert. So the basic of the law for the patent in Indonesia is the second edition, the Law of Republik Indonesia number 13 to 2016. And now there is a draft of revision that are ready to be submitted to the Indonesian Parliament just yesterday. So we are doing a lot of revision, I think. So below the Indonesian law, there are two technical guidance. One technical guidance for substantive examination, and the execution guidance of substantive execution. This is a very thick book. The first book consists of 230 pages, and the execution guide consists of 35 pages. Sorry, there is a chat. Oh, sorry. I must to the full screen. ちょっと待ってください。OK。すみません。Swap display. Okay. Sorry for the inconvenience. So, the first technical guidance, I just found this technical guidance last month after 2 months work. Because the pandemic, everybody must work from home. And I think the Japanese system process business is good, so will be learned from GPO. So the technical guidance books consist of 3 attachments, only 3 what they call. First is on the field of chemistry and pharmacy, Kagaku Yaku. And the second is on biology, and the last is on electrical engineering and electronic, and physics invention that can be implemented on computer system. So the AI is not yet AI technical guidance and AI execution guidance not yet implemented. So the good part of the guidance, there is execution guidance. I think the execution guidance for the substantive examination is on the support of JICA, I think. So I use the picture from JETRO Singapore office survey on appeal, opposition, and invalidation. So there is three, what's it called? The big division. Substantive examination for the opposition, against, and the second is substantive examination for the, I'm sorry, the cursor is not seen, so I changed to the laser pointer. Okay. Okay, the second is substantive examination for the appeal correction. We found that a lot of patentee from foreign country that have translated to Indonesian have very poor translation to Indonesian language, not limited to from English language patent, but also from the other language. So the translation mistakes sometimes very fatal. So sometimes they make for correction. Okay, the second substantive examination is appeal against decision to grant patent from the opponent. So this is maybe typical administrative judge can make decision. Okay. The second chart that I took from the JETRO book is the flow chart of the patent opposition procedure for the patent. Oh, in Indonesia there is differentiation between patent and simple patent. Maybe Indonesia simple patent. There is a term in English different. I forgot the term. After that, after this presentation, I will tell you. Okay. After submission, there is the opposition must use Indonesian patent attorney or proxy with the address inside Indonesia. Okay. After that, they can make a rebuttal. Then maybe after what they call administrative examination between before substantive examination, there is need more time. Okay, the next is, I remember, utility model patent. So the term in Indonesia is simply patent. The period of simply patent is only 10 years, and the ordinary patent is 20 years. Okay. Yes, there is more simply that there is more simple states to the examination. In the ordinary patent, there is 2 steps. First is administrative examination. Then after administrative, the lawyer, the patent lawyer must forward to substantive test. But in simple patent or utility model patent, the 2 examination, the administrative and substantive examination, is one-step procedure, so more simple. Okay, I will jump to the conclusion. This is with the help of JICA expert. Thank you, my friend from JICA. So, in Indonesia patent law, inventive step for AI and IoT-related invention can have substantive examination with regular law and substantive examination and technical guidance. The guidance is not published yet. Then even for me, it's difficult to see. Just last month, I got the guideline because the pandemic, or I don't know. So the guideline is not yet, but I hope we can learn from JPO or other nation patent office. So the examination of AI and IoT related invention can be performed based on existing guidelines. So thank you very much. Domo arigatou gozaimashita. I hope I can learn from the other countries to make the appeal committee in Indonesia is better and faster in this process. Thank you very much.
スティクノ様、ありがとうございました。続きまして、フィリピン知的財産庁特許局副局長アン・エヌ・エディロン様よりご講演いただきます。エディロン様、どうぞよろしくお願いいたします。
Konnichiwa. Good afternoon. Can you see the slides? That's perfect. So good afternoon, everyone. My name is Anne Edilion. I am the Assistant Director of the Bureau of Patents. And I'd like to thank JPO and the Ministry of Japan for inviting the Philippines to be part of this afternoon's discussion. So I will be tackling computer-implemented inventions, particularly because AI and IoT inventions fall within the general category of computer-implemented inventions under the Philippine IP Code. So aside from the Philippine IP Code, we have revised rules and regulations for examination of patents and utility models. And we also have a manual for patent examination. And we also have, in particular, examination guidelines for ICT inventions and computer-implemented inventions. So today, I will be tackling basically the invention application process flow briefly, the appeal and cancellation process, a few statistics that we have on computer-implemented inventions, the basis for grant and therefore the basis of invalidation of examination and inventions, and then an example to show you how we go about the examination and therefore invalidation process. Next slide, please. So this is a chart that shows the flow of invention applications, and you will notice that we actually have two chances to challenge the findings of a patent examiner. It happens during appeals, which is after the final substantive examination, if it's rejected. And then it can also happen at the point of post-grant cancellation. This process for the invention application, as well as the appeals and post-grant cancellation, applies also to utility models, because like Indonesia, we have that also. Next slide, please. So briefly, the process for appeal. The appeal is brought about and filed before the Director of Patents at our office, and it is after a final refusal. So the applicant has 2 months within which to file a notice of appeal, and then 2 months to file an appeal brief. Failure to file an appeal brief will cause the appeal to be dismissed. The examiner who issued the final refusal is also given an opportunity to submit an examiner's brief to refute the arguments in the appeal. And then a reply may be filed by the applicant or not. And then the case now, the appeal is submitted to our office, Office of the Director and the Assistant Director for decision. There is no hearing or oral proceedings involved during appeal for the appeals process. And after analyzing the file wrapper as well as the appeal and the examiner's brief, we issue a decision. If the decision is to grant the appeal, then it is returned or remanded to the patent examiner. So there is no need for appeal. However, the decision is to grant appeal, is to deny the appeal and therefore uphold the final rejection. The applicant can now file an appeal to the Director General, and then so on and so forth. If it is also denied by the Director General, then it can go up to the Court of Appeals and then the Supreme Court of the Philippines. This process applies also to utility models. Next slide, please. So the next slide is, this slide is for cancellation or post-grant cancellation proceedings. In contrast, this one is filed before the Bureau of Legal Affairs, not before the Director of Patents. So it's a petition for, you need to file a petition for cancellation with a certificate of non-forum shopping, a special power of attorney, and other legal requirements required by the Bureau of Legal Affairs. And then the respondent, who is often, the respondent here is the patent owner, has 30 days from receipt of the notice to answer to file their rebuttal. Then it's referred to mediation, wherein both parties try to come to a amicable solution or settlement. And if that does not work, a preliminary conference is then held, and then it is submitted for decision. At this process may or may not involve oral proceedings. So it depends on the case and it depends on the hearing officer. However, because of the COVID-19 situation, we have been doing this completely online since 2020. So both parties will appear usually online via Zoom or any other online conference or meeting platform such as this. Regardless of the decision of the Bureau of Legal Affairs Director, it can be appealed by either party to the Director General of the Intellectual Property Office, and then eventually also again to the Court of Appeals or to the Supreme Court. Next slide. So just a few statistics. The upper left pie chart shows you that we have actually received 90 applications, 90 applications for AI, 54 of them through PCT and 36 from the direct route. The lower pie chart will show you that 88 are currently pending, while 2 have already been granted. And then the chart on the right will show you the number of applications per year. So in 2017, we received 4. In 2018, we received 22. In 2019, we received 40. In 2020, we received 13. And in 2021, we received 11. So if you notice, since 88 are pending and 2 have been registered, we currently do not have any pending appeal for AI or IoT related applications. Next slide, please. This just shows you the top filers in terms of computer implemented inventions, which includes, again, AI and IoT. And the number 1 is actually Accenture Global Solutions. So these are top filers. And then next would be Advanced New Technologies, so on and so forth. It might be interesting for you to note that the third is actually Angel Playing Cards Co., which is a Japanese company. Next slide, please. So when we check for country of origin, quite a lot actually of we included here utility models also. And we noticed that quite a lot of the applications for computer implemented inventions comes from the Philippines, then Cayman Islands, United States of America, China, and then 5th is Japan. Next slide, please. So when we do examination and invalidation, we look at, of course, patentability, novelty, inventiveness, and industrial applicability. So as mentioned in the Philippines, AI and IoT are subsumed under computer implemented inventions. And under the IP code, an invention means any technical solution to a problem. Now, please note that computer programs per se are not patentable under Philippine law. However, they are considered patentable if, such as, let's say, an AI-assisted invention or IoT, it is patentable if the computer-implemented invention has a technical character, such as when it causes further technical effect when run on a computer, or let's say implemented in combination with another computer. So I have a bit more of the slides, but can you please, may I ask the Secretariat to please flash the Inventive Step slide? Please go on. All right. So this is just, yes, I just like to share with the viewers that in the Philippines, we do use a problem and solution approach in determining inventive step. I think novelty is something that's similar across all jurisdictions. If it's new, whether it's technical or non-technical, we consider that as something indicative of novelty. But for inventive step, we do follow the problem solution approach, which involves looking at the closest prior art, determining the difference between prior art and the said invention, and then determining the objective technical problem from the viewpoint of a person skilled in the art, and then deciding if there is an inventive step. Thank you very much for your time, and arigato.
エディロン様、ありがとうございました。続きまして、韓国特許庁特許審判員審判長ヒョン・チェカル様よりご講演いただきます。チェカル様、どうぞよろしくお願いいたします。
Thank you. Good morning and good afternoon, everyone. My name is Hyun Chekal. I am an administrative judge of the Intellectual Property Trial and Appeal Board within Korean Intellectual Property Office. It is a great honor to join this symposium today as a speaker. Next, please. The topic of this symposium is related to artificial intelligence and Internet of Things. I would like to briefly explain the recent reorganization of KIPO Patent Examination Division. The organizational reconstruction was initiated within KIPO in 2019, which led to the establishment of a new Convergence Technology Examination Bureau, dedicated to the examination of technology related to the fourth industrial revolution, such as AI, big data, and biohealth. Before the reorganization, KIPO's patent examination was carried out by 4 bureaus. Next, please. IPTAB has been making its best effort to provide reliable and fair IP dispute resolution. IPTAB has expanded its operations from 11 boards to 36 boards with 36 presiding administrative judges in order to ensure independence, transparency, and expertise of its boards. For your information, the board 8 and 9 are related to AI and IoT. Next, please. This is the procedural flow of trials and appeals. As you can see, IP-related judicial and quasi-judicial system in Korea is based on 3-instance trial system, which is composed of IPTA, TAB or District Court, Patent Court, and the Supreme Court. IPTAB deals with an appeal against a decision to reject an application, trial for correction, trial for invalidation, trial to confirm the scope of rights, and patent opposition. Next, please. From now on, I would like to introduce the KIPO examination guidelines on AI. In order to provide proper protection for inventions with regard to the fourth industrial revolution technologies, KIPO newly established separate criteria on patentability. The guideline outline requirement of patentability and written descriptions, and include various exemplary cases with a focus on convergence technology, such as AI, IoT, biotechnology, and so on. Basically, the guidelines for Inventive Step on AI follow the Chapter 3.2 of the KIPO examination guidelines for general patent and utility model. The inventive steps on AI be admitted if substantial means to implement AI are different and effects are generated from the substantial means with a far better effect. Next, please. I will show 4 hypothetical cases to explain the guidelines one by one. The first case is about users' preference content recommendation device. The only difference between the claim and the prior art in the first case is whether the recommendation is done using the AI technology or not. If AI technology can be simply added before the application date, the claim cannot be patented. Next, please. The second case is about credit scoring. The prior art in the second case disclosed a business method of human works or human business. If human works or human business method can be simply systematized with disclosed AI technology, the claim cannot be patented. Next, please. The third case is about automatic document sorting. The claim and the prior art in the third case are in the same technical field, the automatic document sorting technology. The only difference is the type of neural networks. If 2 types of neural networks, CNNs or RNNs, are well known, it is a matter of a simple design change. Therefore, the claim cannot be patented. Next, please. The last case is about road surface recognition. The only difference between the claim and the prior art in the last case is the pre-processing. However, the pre-processing by analyzing image data from a camera is commonly used before the main digital processing. Therefore, the claim cannot be patented. Next, please. This application is an actual patent application. This invention is related to the assessment of risk factors in workplace. The system collects images of workplace, generates data for training AI, and trains an AI model. As you can see in the images, objects are classified with risk levels, and the data is used to train the AI model. Next, please. The original claim is as shown on the screen. There are no substantial features on the AI models. Collected images are labeled and used to train the AI model. The scope of the claim is quite broad. Next, please. The first prior art D1 disclosed an AI model for automatic labeling. The only difference is the technical field. However, D2 disclosed the technology of recognizing and tracking construction equipment and workers using image processing. The original claim can be reproduced with the combination of D1 and D2. Next, please. The applicant amended the original claim. The applicant specified the AI model with the 2 consecutive models and 2 different training data. The inventive step of the amended claim can be patented despite D1 and D2. This is all I prepared. Thank you very much.
チェカル様、ありがとうございました。最後にシンガポール知的財産庁インターナショナル上級特許審査官ダニー・ヤップ様よりご講演いただきます。ヤップ様、よろしくお願いいたします。
Good afternoon. My name is Danny Yap. I'm a senior patent examiner at the Intellectual Property Office of Singapore, which is IPOS. Next slide. I'll first give a presentation on an overview of the patents trial and appeal system in Singapore. Next slide, please. Firstly, the court system in Singapore. We have a district court and a magistrate court. These two courts make up the state courts, and above this sits the High Court and then the Court of Appeal. For IPOS itself, we do hear hearings and cases. However, any decisions made at IPOS are appealable to the High Court. In terms of domestic patent law, we have the Patents Act, the Patents Rules, and the Patents Composition of Offences Rules. Next slide, please. In terms of dispute resolution in patents, we have a litigation route where cases of revocation, opposition, entitlement, and inventorship may be heard at IPOS. And all these four, together with infringement, may be heard at the courts. However, there's also an alternative dispute resolution route. In this case, disputes can be resolved through negotiation between parties themselves or through mediation, arbitration, and expert determination. And these may be heard at various centers. These are the WIPO Arbitration and Mediation Center, the Singapore International Mediation Center, the Singapore Mediation Center, or the Singapore International Arbitration Center. Next slide, please. The patents process in Singapore has been under the positive grant system since the 14th of February 2014. I'm now going to walk you through the process of a patent application. So starting from the top left, after a patent application is made, a formalities examination will be conducted. And then upon a request for such an examination by the applicant, the patent will go through either one of three routes. There is a local route where there is local search and local examination. There is a mixed route where there is foreign search and local examination. And then there's a foreign route where there is foreign search and foreign examination. However, in the case of a foreign route, this is only open to specific countries. These countries are Australia, Canada, the EPO, Japan, Korea, New Zealand, the UK, and the US. However, this foreign route is currently being closed and is no longer available if the filing date is after the 1st of January 2020. Moving on, after the search and/or examination, this will result in either a positive report or a negative report. In the case of a positive report, a patent will be granted. However, in the case of a negative report, the applicant may then request for an examination review. This examination review will result in either a positive review, in which case a patent is granted, or a negative review, in which the patent is refused. If the patent is refused, the applicant still has the option of raising a divisional application and putting the patent through the patent application process again with amendments. However, the applicant may also appeal the decision of the examination review to the High Court. And on the top right, you can see that even if a patent is granted, there are revocation procedures. These revocation procedures may be heard either in IPOS itself or in a High Court. In cases where the revocation procedure is heard in IPOS, this may be appealed to the High Court if it is refused. Next slide, please. In terms of the examination review procedure, there is first a request for examination review made by the applicant. This is usually accompanied by written arguments and proposed amendments. There will then be a formalities check, and then there'll be a consideration of amendments and/or written arguments by the review examiner. At this point, the review examiner may request for further arguments by the applicant. before issuing an examination review report. And if the examination review report is positive, the patent will be granted. If not, it will be refused. And as mentioned earlier, the applicant may, upon refusal of his examination of his patent, appeal the decision to the courts. The number of examination review reports issued in 2018 was 108. In 2019, it was 71. And in 2020, it was 63. Next slide, please. The patent revocation procedure at IPOS follows a very fixed timeline and very specific steps. I will not go through the revocation procedure in detail. It really depends on whether proposed amendments are made in the counterstatement stage. But it starts with an application for revocation. There is a statement, there is a counterstatement, and then proposed amendments. And then there is a series of case management conferences where the applicant's evidence and the proprietor's evidence is heard. Next slide, please. At this point, the re-examination of the specification may be called for. And then after a case management conference, there will be a hearing, and then a grounds of decision will be issued. This grounds of decision may be appealed to the courts. And then finally, there is optionally a taxation stage. In this stage, the costs awarded to parties may be heard. Next slide, please. Statistics for IP disputes at IPOS. There were 784 cases filed at IPOS in 2020. These are predominantly in the area of trademarks. So on the right, several tables. The number of patent disputes filed in 2018, there were only 3. 2019, 2, and in 2020, there were only 2. In terms of hearing decisions at IPOS in 2020, there were 22 in trademarks and none in patents. Similarly, in court decisions in Singapore in 2020, in trademarks, there were 5 court decisions. In patents, there were none. Next slide, please. I'll now move on to the determination of inventive step for patent applications. Next slide. At present, there have been no court decisions involving AI or IoT patents in Singapore. There are also currently no guidelines for the determination of inventive step that are specific to AI or IoT. At the Patent Office, AI and IoT are examined as computer-implemented inventions. To determine inventive step for any patent, the courts here have adopted the windsurfing test. The windsurfing test is a 4-step test. The first step is to identify the claimed inventive concept. The second step is to assume the mental of the skilled person with the common general knowledge of the art in question at the priority date. The third step is to identify any differences between the alleged invention and the prior art. And the fourth step is to decide whether these differences would have been obvious to the person skilled in the art. Next step. Next slide, please. Combining documents for inventive step. Combining displays or mosaicing documents for assessing inventive step is allowed. However, an assessment whether the person skilled in the art would combine such disclosures must first be undertaken. Some considerations for combining disclosures are, first, would the nature of the documents influence the skilled person to combine them? Are the documents from the same technical field? Are there references in one document to the other document? How much selection is required to isolate the separate disclosures from each document? And fifth, is one document so well known that a skilled person would have it in mind? There is no limit to the number of documents that may be combined. However, the greater the number of features to be combined, the greater the likelihood that the claim is inventive. Next slide, please. Patentable subject matter. Although there are no specific guidelines for the determination of inventive step for AI or IoT, there are guidelines that may apply to AI relating to patentable subject matter. If the actual contribution of an AI patent claim is found to be a pure mathematical method or algorithm, the claim is not considered to define an invention under the Patents Act. To be considered an invention, a mathematical method or algorithm must be functionally limited in the claim to solve a specific as opposed to a generic problem. A quick example is If you have a claim for a deep learning AI method characterized only by the mathematical steps, the actual contribution is likely to be a pure mathematical method or an algorithm. However, you have a claim for the same method to process audio or video data in order to recognize human speech. In this case, the actual contribution here is likely to define an invention. Next slide. Thank you for your attention. That's the end of my presentation.
ヤップ様、ありがとうございました。以上で講演を終了いたします。ご登壇の皆様、ありがとうございました。